against Enviroco Limited and another.
Lord Clarke will give the judgment to the court.
This appeal arose out of a fire on an oil rig supply vessel as long ago as July 2002. The vessel was owned by a company called Farstad, which had chartered the vessel to a company called Asco. Asco engaged a company called Enviroco to clean the vessel's tanks. The fire broke out during the tank cleaning, causing damage to the vessel. Farstad claimed damages against Enviroco, alleging that the fire was caused by Enviroco's negligence. Enviroco said that the fire was caused in part by Farstad's contributory negligence and also claimed a contribution against Asco on the basis that the fire was also caused, at least in part, by Asco's negligence. The claim for contribution was brought under Section 3, subsection 2 of the Law Reform Miscellaneous Provisions, Scotland Act 1940. The appeal to the Supreme Court raised a number of preliminary issues on which the court reached these conclusions. 1, that the question under Section 3, subsection 2 was whether, if Asco had been sued by Farstad, it would have been liable to Farstad for the consequences of the fire. 2, that the answer to that question depended upon whether Asco would have had a defence to Farstad's claim under the terms of the Charter Party. 3, that Asco would have had a defence under the Charter Party by reason of clause 33.5, by which Farstad agreed to, quote, defend, indemnify and hold harmless, unquote, Asco from all liabilities resulting in damage to the vessel. Because clause 33.5 is an exclusion clause, and or 4, that even if clause 33.5 is an indemnity clause and not an exclusion clause, Farstad's claim against Asco would have failed for what in English law is called security of action and in Scots law is expressed by the brocar frustra petis quod mox eis restiturus. In reaching those conclusions, the court preferred the opinion of the Lord Ordinary in the outer house of the Court of Session to that of the majority in the inner house. It accordingly makes an order in these terms. 1, the appeal be allowed. 2, the interlocutor of the inner house dated 1st May 2009 be recalled. 3, the interlocutor of the Lord Ordinary dated 23rd April 2008 be restored. 4, the cause be remitted to the Lord Ordinary to proceed as accords. And 5, that the respondents pay the appellant's costs in the Supreme Court.
Judgment in the appeal, Inveresk plc against Tullis Papermakers Limited.
Lord Roger will give the judgment to the court.
On the 9th of June 2005, Tullis Russell entered into an asset purchase agreement and a related service agreement with Inveresk for the acquisition of the property rights to the Gemini brand of paper. The consideration for the acquisition includes a sum of up to £2 million as additional consideration, depending upon the volume of products sold and invoiced by Tullis Russell between 8th of November 2005 and the 8th of November 2006. Inveresk claims that it is entitled to a further sum of around £900,000 as additional consideration under the asset purchase agreement. Tullis Russell claims that Inveresk breached the asset purchase agreement and service agreement by failing to maintain required product quality standards and dealing with customers so as to damage the goodwill of the business. It seeks around £5.3 million in damages. 2 issues arise in the appeal. Firstly, whether the additional consideration claimed by Inveresk has been ascertained under the terms of the asset purchase agreement. And secondly, whether Tullis Russell has a right to retain the sum it claims in damages pending resolution of the claim against any payment it is required to make to Inveresk. The Court of Session held that the additional consideration sought was due and payable, and that no right of retention was made out. The Supreme Court unanimously allows the appeal. In relation to the first issue, the operative provisions of the asset purchase agreement clearly direct that, having elected to exercise its right to require a tonnage audit, Inveresk is not entitled to change its position on this issue. The procedure provided for in the asset purchase agreement to determine the additional consideration has not been completed, and the additional consideration claimed by Inveresk has therefore not been ascertained. The matter is remitted to the commercial judge to determine how the conduct of the tonnage audit should proceed. In relation to the second issue, the Court concludes that, in this particular case, the two agreements have to be looked at together, and that Tullis Russell's obligation to pay the additional consideration to Inveresk should be regarded as a counterpart of Inveresk's performance of its obligations under both agreements. Even if the additional consideration were ascertained, Tullis Russell would be entitled to withhold payment of that sum until the Court decides whether Inveresk fulfilled its obligations under the service agreement. The matter is remitted to the commercial judge for further procedure.